We're following new developments this morning in the Jeffrey Epstein case. The U.S. Justice Department filing a new memo on why it believes a judge can unseal grand jury testimony from Epstein's longtime accomplice and convicted sex trafficker, Ghislaine Maxwell. We're also learning that Maxwell has agreed to testify before Congress, but only if some major demands are met. CNN senior legal analyst and former state and federal prosecutor Elie Honig is joining us right now. Elie, let's start with this memo from the Justice Department. What's the argument here?
Well, Wolf, it is extraordinarily unusual to see DOJ make a move that they made last week when they went and asked various judges, 3 different judges, to release grand jury testimony relating to the prosecutions of Jeffrey Epstein and Ghislaine Maxwell. The very purpose of the grand jury ordinarily is secrecy. Now, the law says you can only unseal those secret records in certain very narrow circumstances, none of which really apply here. You can really only unseal if some other prosecutor or some other criminal defendant needs the case. There's really not some sort of catch-all exception for there's huge public interest. Now, because DOJ is sort of fighting an uphill climb here, they lost. The Florida judge already denied their motion. The other motions are still pending in New York with the 2 New York judges. And what this memo is trying to do is justify this very unusual action by DOJ by saying essentially there's a very high public interest. But again, important to remember, that's not specifically cited as an exception to the rule. We'll see whether the judges in New York are persuaded.
Ghislaine Maxwell, as you know, Elie, is demanding immunity, along with a slew of other demands, before she agrees to testify before Congress. It's something the House Oversight Committee is flatly rejecting, at least right now. How significant is this immunity demand?
Well, some of Ghislaine Maxwell's demands are silly, and I think she's not entitled to, for example, being shown the questions in advance. That's fairly ridiculous. However, the reasonable part of Ghislaine Maxwell's response to the request for testimony is to take the Fifth. She still has a pending case in front of the Supreme Court. The Supreme Court has not taken the case, but she's trying to get them to take it. And so theoretically, she could, it's unlikely, but she could win and end up with a new trial. So she's right to take the Fifth. Now, immunity is Congress's tool. That's up to Congress. If they want Ghislaine Maxwell's testimony, now that she's taken the Fifth, they can grant her immunity. That would not release her, Wolf, from her prior conviction or her 20-year sentence. That would just mean that any testimony she gives to Congress cannot be used against her moving forward. So that sort of puts the ball over in Congress's court. And I think it's telling that so far Congress, as you said, Wolf, has said, we're not giving her immunity. That sort of begs the question to me, why would you have subpoenaed her in the first place if you're not willing to do what it takes to actually get that testimony?
Maxwell's lawyers are still angling for a possible pardon, something President